I don't know if you don't think that you have to follow the rules, or if you have this mentality that you're a tough guy, that you can just do whatever you want, but you're not going to here. So the court's going to find today that you are not amenable to community control, that prison is necessary to fulfill the purposes and the principles of sentencing, including punishment, deterrence, and protection of the public. So on count one, I think it's count one. On count one, the assault charge, the court's going to order you to serve 24 months in prison. You can't be assaulting people because you don't like what they're telling you to do. These are corrections officers that already have a difficult enough job. And it just irritates me that you think that you can just be a bully to them. It doesn't work that way. On count two, the court's going to order you to serve 12 months in prison. That to be served consecutive to the 24 months. The court finds that a consecutive sentence is necessary to punish this defendant and to protect the public from you. It is not disproportionate to the conduct or danger posed by the defendant, and these offenses were committed while the defendant was serving a PRC sentence in the Department of Rehabilitation and Corrections. You have 95 days jail time credit. The court finds that you're indigent for the purposes of any fines, costs, or other financial sanctions. You're also subject to a discretionary period of post-release control. When you are released, the adult parole authority shall once again try to supervise you for up to 2 years. If you violate that supervision, they can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year, or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. There may be opportunities for you to receive up to 1 day per month for participating in certain education, vocation, or other programs sponsored by the Department of Corrections. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. One final thing, Mr. Zhang, before you leave. I want to offer you today some hope for your future. So I'm telling you today that after you are sent to the institution, I will consider a motion for judicial release after an appropriate period of time. But I'm telling you right now that I will not tolerate any infractions from you in whatever institution they send you to, whether it's in our county. We have 2, Warren and Lebanon. Whatever institution they send you to, you must abide by all of the rules of the institution. 0 infractions. You need to demonstrate to me that you want to live in our society. Otherwise, you're just going to be in and out of prisons for the rest of your life, and you're only 28 years old. This is your 3rd stint in prison. So I want to offer you that hope, and I'm willing to try this, what Ms. Diefenbach said, this recommendation for the CBCF, the treatment facility, and I will consider it. But if you're going to go in there and you're going to violate the rules, don't bother filing your motion, because I'll deny it.
Yes.
Are we clear on that?
Yes, Your Honor.
Can you follow the rules?
Yes, I can.
All right, good luck to you.
And the real thing, call me.
Okay.
Mr. Wade here?
Mr. Wade is here.
Okay. Just simply please, sir.
These are case numbers 25CR42948, 25CR43081, the State of Ohio versus Jerome Wade. You made it back, right?
Yes.
All right. We are here for a final probation violation hearing. Ms. Diefenbach, does your client wish to have a hearing?
You want a hearing or you want to admit to the violation?
I wish to have hearing.
You do, because you didn't report. That's what that's why. You admit you didn't report?
Oh, yes.
The allegations were that you failed to report and that you were positive for THC, correct?
Correct.
You want to have a hearing on that, or do you want to admit to the
I
violation?
want to admit to the
All right,
violation.
court's going to find that you have violated the terms of your community control. Mr. Wade, despite this violation, the court is going to continue you on community control. To date, you have 64 days jail time credit. Is there a recommendation for him to engage in treatment?
Yes, Your Honor, there's a recommendation from Calvert House for both mental health and substance use.
You are ordered to comply with that assessment. You are to engage immediately when you return to Cleveland in mental health and substance use disorder treatment. Do you understand?
Yes.
Was he positive today?
I believe he was still
I was
reading
negative.
negative.
Negative for everything?
Yes.
You can do it. See? All right. So again, no alcohol, no illegal drugs, no marijuana. Do you understand me?
Yes.
All right. Mr. Wade, I'm not going to keep doing this, so you understand if you don't comply with the terms of my orders, then the next time you'll probably just be serving timeout, okay? You can do this. Get it right. Are we together? Are we on this? Okay, good luck. That's all.
Okay.
All right, you want to talk to him?
Yes, I need to.
All right, head back down to court services. She's going to want to talk to you before you leave.
Okay.
Ready?
Yes, Your Honor.
Case number 25CR43134, the state of Ohio versus Noah Bays. Mr. Bays is before the court with his counsel, Mr. Abood, Ms. Nicholson, Mr. Knippen. On behalf of the state of Ohio, we are here for sentencing. There was a pre-sentence investigation that was prepared. Has everyone had an opportunity to review that?
Yes, Your Honor.
Yes, Judge.
All right, Mr. Knippen?
Your Honor, a couple of preliminary matters first, and then I have two victims that would like to address the court, and then I would like to come back and address the court as well. But as to the preliminary matters, it's the state's understanding, I believe defense is in agreement that counts 1, 2, and 3 all merge for purposes of sentencing, and the state is electing to proceed on count 1. Also, counts 4, 5, and 6 would merge for purposes of sentencing, and the state is electing to proceed on count 4, both of those being the attempted murder offenses. Additionally, the state is requesting $200 in restitution for Emily Bair, B-A-I-R. Also, $1,300 in restitution for Rebecca Noble, and also $1,000 in restitution for Jeff Piper. And with that, Your Honor, I would invite Mr. Piper to come up and make a statement to the court.
Just state your name for me, please.
Jeff Piper.
Good afternoon, sir.
Good afternoon, sir. Thank you, Your Honor, and thank you for the opportunity to stand before you and to briefly share how this event has forever changed the life of my wife, my daughter, and myself. As a brief background, just over a week prior to this event, my wife had total knee replacement surgery. She had very limited mobility and was recovering from the surgery. That day started just like each day in the past had started. My wife was doing her rehab and her strength training to improve her healing and mobility. I'd taken off work to care for my wife. My daughter had taken the day off to come and to help take care of her while I ran some errands. While I was running errands, my daughter called and stated that my wife had a high fever. This was alarming because we were concerned for infection and blood clots. I returned home from my errands, and our daughter had gone to go purchase some medical items, and then I began to unload the items from my vehicle and to bring them into the house and to place them in the pantry. While doing so, there were numerous, what sounded like loud pounding on our front door. I looked out the window in the front, and I observed nothing. I then looked into the intersection, and I saw a vehicle stopped in the intersection. I walked down to the intersection and made contact with the first victim. It was at this point that the driver stated that she had been shot in the arm. I observed a second vehicle a short distance away, and a male subject was performing what I thought was CPR. I approached them, and I stated, and he stated that he had that the driver had also been shot as well. He was not performing CPR, but he was applying pressure to the wound. I contacted 911 and I advised them of what was going on, and then began to perform first aid to the subjects. I had them retrieve a first aid bag out of my truck, and they used it to apply a tourniquet and other first aid life-saving measures. I called my wife to let her know what was going on, and she advised me that the doctor had called her back and said, "You need to get to the hospital immediately." Unfortunately, due to the house being the center of a crime scene and I was attending to victims, that was prolonged until my son was able to arrive and to take her to the hospital. In the hours after the event, I checked the house to see if there was any damage, and I didn't find anything. Our daughter spent the night at our house, and she advised that the electricity was out in her bedroom. I waited. It wasn't until a couple days later when I discovered that a bullet had entered through the bedroom window across the hall from her and went through behind a reef that was hanging on the window, went through the window, across the hallway, and through 5 sheets of drywall. And then finally came to rest at the exterior of our house where the bullet finally came to rest at bricks of the exterior wall. Additionally, as I later began to process what was going on, the hole in the hallway to which I was traveling up and down was approximately 4 inches or less above my head. And at any moment, if things would have been different, I could have been walking through that hallway. As a public servant, I'm trained to handle other people's situations, and this day directly impacted my family. I could not control this situation. The individuals who fired on the shots on this house, fortunately, was not successful in his mission. However, the trauma will remain for the entirety of our lives. When cars drive by slowly, when there are loud noises, when there are people recreational shooting firearms or fireworks, headlights shine through our windows, all of this creates a heightened sense of awareness for me. That day forever changed my life and the lives of so many people, the victims, my neighbors, those driving on the road, the family members of all the individuals involved, and my family. Thank you to the first responders and the staff of the Warren County Sheriff's Office for the countless hours that they put into this case. Thank you once again for the opportunity to share and to stand before you and how this event has changed my life.
Thank you, sir.
Hi, my name is Emily Bear, and I would like to thank you for this opportunity to address the court. I feel very fortunate to be here today. I am the maternal grandmother of Noah's 13-year-old daughter. I have known Noah for approximately 15 years. His daughter has lived in my home her entire life, and I have had primary custody of her since she was 9 months old, and Noah had weekend visitation. In May of 2025, he filed for custody of my granddaughter. She did not want to live with him, and I did not feel it was in her best interest to do so. We had several hearings on the custody case, and this incident occurred 9 days prior to the day that we were set to have our trial in juvenile court. I believe that he had every intention of killing me that day. It was the most terrifying experience of my life. I think about it every day. It has changed the way I think and the sense of safety I once had. It is impossible to fully explain what it feels like to know that you came within inches of losing your life at the hands of someone you had known for so long and once trusted. The shot that hit me in the leg was very painful. It was difficult to walk, and I couldn't bend my knee for several weeks. My vehicle was destroyed. It took 3 months for me to replace it. And during that time, I had to figure out how to get to and from work and anywhere else I needed to go. This trauma has not only affected me, but my entire family. It has caused a tremendous amount of fear, stress, and emotional strain. We are trying to rebuild a sense of normalcy. Noah's actions that day put my life and the life of several others in serious danger. This will have long-lasting effect on everyone that was involved. I respectfully ask the court to impose a sentence that reflects the seriousness of the crime, recognize the damage that he has caused, and protects the community from future harm. Thank you.
Thank you.
Your Honor, Ms. Noble was not able to come today because she indicated that it created too much anxiety for her to be here and to address the court, to kind of go through this situation again. But she did state to our office that she believed that you would do the right thing. So I think what I want to address right out of the gate is the absurdity of some of the statements in the letter that the defendant submitted to you. In the letter, the defendant stated, and I quote, "I have no recollection of these things and would never do them in my right mind, no matter how angry or mad I was at someone. I am far from a violent person, even when angry," end quote. Think about that for a second. He wants you to believe that despite all of the planning and preparation that went into that day, he can't remember any of it because he was not in his, quote, right mind. Your Honor, the facts of that day demonstrate that that statement is a complete and total lie. This is someone who got up that morning and called off work so that he could specifically carry out this shooting. He then put on all black clothing and loaded his assault rifle into his car in a way that he would not be detected by the camera at the front of the house. He then drove over 50 miles from his residence in Piqua to Wayne Township to carry out this shooting. This shows the distance and time that he traveled to come all the way here to carry out this violent attack. When he arrived in Wayne Township, he concealed himself down a long lane and hid in a tree line for over 20 minutes while he waited for Emily Bear to pass through that intersection. And the reason that he knew Emily would be traveling through that specific intersection is because he had looked at the Life 360 app on his daughter's phone in the days leading up to this shooting, which showed that Emily went home every day during her lunch hour. Once Emily entered the intersection, he fired multiple rounds from his rifle, repeatedly striking her vehicle. Look at that firearm, Your Honor. Look at the ammunition that he was using. And now look at the location of the bullets on Emily Bear's vehicle. All over the doorway. Your Honor, these were all intended headshots. He was not intending to injure Emily Bear on that day. Rather, he was intending to kill her. After striking and injuring Ms. Bear, the defendant continued firing and struck the vehicle directly behind Ms. Bear, which was driven by Ms. Noble, causing her injury as well. To this day, she still has a bullet in her body. Additionally, we know that one of the bullets struck Mr. Piper's house across the street, putting the occupants of that home in danger as well. The defendant then drove all the way back to Piqua, dropped off the firearm back in his bedroom, again without being detected by the camera at the front of the house, changed his clothes, and then went to the local Speedway to buy cigarettes. When he returned to his residence and was apprehended by the police, he immediately began lying, claiming that he had been home all day other than his quick trip to Speedway. When he was interviewed by detectives later that evening, he continued to lie, claiming that he was only gone from the house that day for about 10 minutes. And he further told them that the only gun he owned was a shotgun that was used for trap shooting. Think about all of the actions that the defendant took that day, the planning and preparation to carry out this shooting, and the efforts he took to cover up his actions. And now he wants you to believe that he doesn't remember anything about that day. And remember, he's not claiming that he was intoxicated or that he was high. He was perfectly sober. He just wants you to believe that for some mysterious reason, he has no recollection of that day at all. That's absurd. What he's really trying to do, Your Honor, is to get credit for accepting responsibility by entering a no contest plea while still professing and hoping that you will believe that someone like him would never commit such a violent attack if he was only in his right state of mind. What a coward. If you're going to accept responsibility for something, own it. Don't try to hide behind this phony nonsense about not being able to remember when there is zero evidence that you were under the influence or suffering a mental break. What's even more surprising in the sentencing memorandum offered by the defendant is the assertion that he did not have any concerns for his child's safety when she was with Emily Baer, and that Emily consistently provided a loving and stable home for his daughter. So that means that he was willing to kill someone who had voluntarily raised his daughter from birth and only showed her love and affection. And think about what this would have meant for his daughter if his plan had actually worked. If the defendant was successful, and if things had gone perfectly that day for him, he would have gotten away with murder, and his daughter would have always been left to wonder why her grandmother, her primary caretaker and provider, was gunned down in the middle of an intersection for no apparent reason. That was the defendant's preferred outcome for that day. One of the last things that I would point out is that the factors that the defendant highlights in his sentencing memorandum, demonstrating why he should receive a more lenient sentence, actually makes him all the more dangerous. No one saw this coming. Even Emily, when she was asked shortly after the shooting whether the defendant could have been involved, stated that she did not think that he would do something like this. The fact that there were no outward signs of anger or aggression towards Emily makes the methodical and calculated actions of the defendant all the more concerning. No one thought the defendant was capable of such a violent and senseless plot to murder someone. That's borne out in all of the letters that the court received. Only he knew what he was truly capable of, and because of that, he almost got away with it. Finally, Your Honor, there is one sentiment in the defendant's letter that I actually agree with. At the conclusion of the letter, the defendant suggested to you that 20 to 30 years in prison would not be appropriate for someone like him. And I couldn't agree more. 20 to 30 years is too light for what this defendant did. When you consider all that the defendant did to carry out this attempted murder of Emily Baer, when you consider the fact that a completely innocent third party was shot and injured in broad daylight just for driving her vehicle through an intersection, and when you consider the fact that he fired so indiscriminately and so many times that one of those bullets went into the home of another completely innocent third party, 20 to 30 years doesn't seem like enough for all that the defendant did on that day. Therefore, we think a sentence in the range of 30 to 40 years is more appropriate when you consider all of the facts and circumstances and take into account that he is still being dishonest with this court with that self-serving letter he submitted, claiming to have no memory of that entire day. Thank you, Your Honor.
Thank you. Anything from probation? Mr. Booth,
Judge, you want us here at the podium?
at the podium, please.
Yes, sir.
Go ahead.
Judge, thank you. As a court, we spoke about this matter in chamber. The court acknowledged that defense did file a sentencing memorandum in this case, and it's also referenced by Mr. Knippen's speech as well. I wasn't planning on saying anything further, but I feel like a response, at least to Mr. Knippen's statements, I think they're a bit disingenuous in terms of how he's characterizing Mr. Bays' letter and all the letters and support that were provided. And part of a sentencing memorandum is defense asked the court in mitigation to look all the sentencing factors and sentence an individual that's consistent to the circumstance with all other cases that the court has looked at and similar in nature. And I understand this is an allegation of a violent offense, but Mr. Bays did plead no contest. And part of that is, and from a defense lawyer's point of view, is there's an acceptance of responsibility for the purposes of a sentencing, but also he's still maintaining the no contest plea based upon the advice of counsel, and he intends to appeal for the purposes of some pretrial motions that we've had in this matter. So I think I don't want the court to consider that based upon my advice that Mr. Bays did accept responsibility for the purposes of writing a letter to the court. I think he should be given credit for that in terms of what he's done, and all the other letters and support that were provided on behalf of Mr. Bays, and ask the court to follow the sentencing, the principles and purposes of the statute in terms of sentencing, and sentence Mr. Bays consistent to what other cases that have come before the court. Also, Judge, I would note, I don't think I addressed this in my sentencing memorandum, but for the purposes of any financial sanctions, Mr. Bays has been incarcerated in this county jail since October of 2025. He's obviously had no income. That's the court to consider that any financial sanctions. But other than what I put in my sentencing memorandum, I think Mr. Bays is ready to proceed to sentencing, Judge.
Mr. Bays, is there anything you'd like to say?
No, sir.
All right. The court has considered the statements made here today, the purposes and the principles of sentencing, including punishment, deterrence, and protection of the public. The court has reviewed the pre-sentence investigation and has reviewed the sentencing memorandum and letters attached that have been submitted by the defendant. Mr. Bays, I got to tell you, I've been on the bench for almost 10 years now, and I have never seen anyone that has done so much prior calculation and design, formulating a plan to go and to lie in wait and ambush someone that they know over a potential court ruling. This is new to me. I mean, you read stories of people driving across the country and shooting and killing a former family member or something. Didn't think it would ever happen in Warren County. I live in this community. I am shocked by your conduct. I'm shocked by what I perceive to be as your lack of remorse, your lack of accountability. But I don't even know what else to say. But I'm going to tell you right now that from my perspective, the overriding principle of sentencing that I'm considering is not only punishment, but I have to protect my community. So the court does find that a prison sentence is necessary to fulfill the purposes and principles of sentencing. The court is dealing with multiple offenses arising from the same incident. Court does find that counts 1, 2, and 3 merged. Counts 2 and 3 merge, the state electing to proceed on count 1. And as to counts 4, 5, and 6, counts 5 and 6 merge as they are allied offenses of similar import. Into count 4, the state electing to proceed on count 4. So on count 1, the court is going to order you to serve a minimum term sentence of 10 years, a maximum term sentence of 15 years. On count 2, the court is going to order you to serve a sentence of 10 years. Strike that. Let me back up. On count 1, 10 to 15 years plus 3 years on the gun spec. That to be served by law consecutive to the 10 years. On count 4, the court is going to order you to serve 10 years in prison plus 3 years on that gun spec, those both to be served consecutive to each other and consecutive to count 1. On count 7, the discharge offense, the court is going to order you to serve 3 years in prison plus the 3-year gun spec, those to be served consecutive to each other and consecutive to count 1 and 4. And on count 8, the court is going to order you to serve 3 years in prison and 3 years on the gun spec, those to be served concurrent with each other and concurrent with count 1, 4, and 7. You have 246 days jail time credit. I'm ordering restitution to Emily Bair in the sum of $200, to Jeff Piper in the sum of $1,000, in the sum of $1,300 to Rebecca Noble, I apologize. Other than those restitution orders, the court finds that you're indigent for the purpose of other fines, costs, or financial sanctions. You're also subject to a mandatory period of post-release control. which means that when you are released from prison, the adult parole authority will supervise you for not less than 2 years, nor more than 5 years. If you violate that supervision, the adult parole authority can return you to prison for up to 1/2 of the court's original minimum term sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. It is possible, these are mandatory sentences, so I'm not going to get into the good time. You have been convicted of or pleaded guilty to a qualifying violent offender offense as defined in the Ohio Revised Code. You are not, have you seen this?
Yeah, no, I have not.
You have not? You want me to go over this with you on the record?
No, thank you.
You want to waive it?
Um,
I'm going to waive reading this. I'm going to have the probation officer sit down with him and have him sign it. Do you want me to go on the record with it?
Judge, for the purposes of the appellate record, I think that would be appropriate in this
Okay.
case.
If you are not sentenced to a prison term, you are required to enroll in the violent offender database personally with the sheriff of the county in which you reside 10 days after being sentenced. If you were sentenced to prison, which you are, you must enroll in the database personally with the sheriff of the county in which you reside 10 days after your release from prison. If you're an out-of-state offender, you must enroll in the database personally with the sheriff of the county in which you reside or occupy a dwelling within 10 days of either residing in or occupying a dwelling in Ohio for more than 3 consecutive days, or residing in or occupying a dwelling in Ohio for an aggregate period in a calendar year of 14 or more days. You are required to provide the sheriff certain information, including your full name and any alias you use, your residence address, your social security number, driver's license number, commercial driver's license number, state identification card number issued to you, information regarding the offense of which you were convicted or pleaded guilty, the name and address of any place where you are employed, the name and address of any school or institution of higher education you attend, the license plate number of each vehicle owned or operated by you or registered in your name, the vehicle identification number of each vehicle and a description of each vehicle, a description of any scars, tattoos, or other distinguishing marks on your person. You are required to provide the sheriff fingerprints and palm prints. The sheriff will also obtain a photograph of you at the time of enrollment. After the date of initial enrollment, you are required to re-enroll annually. You must update and or amend any of the information described above that has changed and provide any additional information requested at the county sheriff's office within 10 days of the anniversary of the calendar date on which you initially enrolled. If you change your residence address during the 10-year enrollment period, you shall provide written notice of that change to the sheriff with whom you most recently enrolled and to the sheriff in the county in which you intend to reside within 3 business days of the change of address. You are required to comply with all of these above described requirements for a period of 10 years unless your sentencing court determines otherwise. Since your expected residence address is located in Miami County, you shall enroll in person no later than 10 days after you're released from prison with that county sheriff's office in Troy. Failure to enroll or failure to verify residence at the specified times will result in criminal prosecution. All right. Mr. Knippen, is there anything else, sir?
Your Honor, I think the only thing left is that, for you to make the consecutive sentence finding.
I did.
Is that correct? Okay.
I said I did.
Okay.
I can make them again. Consecutive sentences are necessary to punish this defendant and to protect the public from future crime. It is not disproportionate to the conduct or danger posed by the defendant. And these offenses were part of a course of conduct, and the harm caused is so great or unusual that a single prison term would not adequately reflect the seriousness of the conduct.
Thank you, Your Honor.
Thank you. Anything else?
No, Your Honor.
Mr. Boot.
Judge, only that for the court to note the defense's objection with respect to the court sentence today for the purpose of the appellate record.
To my sentence,
Yes, sir.
I would anticipate.
Some courtroom hearings end with probation. Others end with a sentence that changes a person's life forever. This was one of those cases. After listening to the evidence, the victim impact statements, and the arguments from both sides, the judge reached a conclusion that left no doubt about how serious he believed these crimes were. Looking directly at the defendant, The judge said the biggest factors influencing his decision were the defendant's lack of remorse and lack of accountability. He explained that sentencing isn't only about punishing someone for what they've done, it's also about protecting innocent people from future violence. In the judge's view, the defendant had shown no meaningful acceptance of responsibility, making a lengthy prison sentence necessary to keep the community safe. It was a powerful moment that changed the atmosphere inside the courtroom. The judge